what we'll be doing right now is we'll go ahead and get started, and I'll have Brad introduce himself and sort of get into his presentation. This will be recorded as well, but like I said, it will take some time for it to be back up on our website. So this is not going to be immediate. If you leave today, this information may be there eventually, but not quite immediately. Brad, I'll hand it off to you.
All right, awesome. Thank you, Nathaniel. I appreciate it. Thanks everybody for taking the time to join. Nathaniel mentioned I am an immigration attorney in private practice. I've been doing this for, time flies, but close to 20 years. So I appreciate the opportunity. I always like having the opportunity to speak to students. You guys always have good questions, and it's nice to see people exploring their options here at the beginnings of their careers, or even at the early stages, I should say, for some of you who may not be at the exact beginning. So what I typically do with this is I talk first with just a few basics of immigration, just to make sure that we're on the same page, try to make sure that we're all speaking the same language, as it were. And then we'll talk a little bit about some non-immigrant visa options for what to do after graduation, some potential permanent residence options. And then at the end, we'll talk about a few alternatives and advice. I'm definitely anxious to hear from you guys. As you formulate some of those questions, hopefully I'll be able to answer them during the presentation, but if not, definitely look forward to questions afterwards. So just to start with a few of the basics, and we're talking about really basic, how do people come to the United States? So generally people are going to come legally in one of three ways. By far the most common are people who come with what are called non-immigrant visas. I would imagine this is most of the people who are here today. If you came on an F1, a J1, it's a non-immigrant or temporary visa. It is for a specific time frame, a specific purpose. There are some folks that actually enter the U.S. with an immigrant visa, which is essentially a green card. It is possible that somebody's very first steps into the U.S. Would be clearing customs and being admitted as a permanent resident. Not as common, but it does happen for some folks. There are also humanitarian programs that bring people in, refugees, although not as many as it used to be. And then that last category, EWI, stands for entry without inspection. So if you came in with no paperwork whatsoever, or somebody else's paperwork, that is an entry without inspection. Your options are extremely limited if you have entered without inspection. We're not going to focus much on that today. So typically, most people will come in and we want to talk about non-immigrant visas and the difference between a visa and status. This is a visa. I always tell people this is not one of my clients. I always respect confidentiality, but this is a visa, and this is what allows somebody to present themselves for entry into the United States. Now, generally, the only way to get a visa as of today is at a consulate abroad. And it has been that way for about the last 20 years. They did very recently announce some plans to potentially change that rule for certain people who hold H or L visas, but it's a pilot program, and not a whole lot is known about it right now. But this slide may be changing for future presentations. But as of today, the only way to get a visa is to actually visit outside. Now you can see this particular visa is good for 5 years. It allows somebody to present themselves multiple times to be admitted into F1 status. Now the visa and the visa length is very different than status. And once you're here in the United States, status is what's particularly important. The way that you're going to have evidence of your status is through one of two different types of documents. One of these, which is over here on, I guess if you're facing at the left side of the screen, is an online I-94 record, which is obtained through Customs and Border Protection when you come in. And this is what grants you status, a certain type of immigration status. And with that I-94 document, it will tell you what class of status you're in and how long you're allowed to stay. Now, something to make note of is that the time on your visa may not match the exact amount of time on your status. It is also possible for some of you who may have had a visitor visa to come in before to maybe look at school and then obtained an F1 or a J1, that they have admitted you in the wrong status. So it is always really important that after you come in that you double check this document, that you can check online and make sure that it accurately reflects your current status. The other way to do that is to obtain a change of status document. That'll be on the, if you're facing, that's the right side. This document over here, which is obtained from United States Citizenship and Immigration Service, or USCIS. And you can see what they do with this document is they send you actually a new I-94 card right here on the bottom. That new I-94 card is proof of your new status. So I always want to tell people that you're going to have some sort of document that proves what your status is. It is critical to maintain your status, because once you lose it, typically in most cases, you're going to have to depart and make a fresh re-entry. And sometimes that means going to the consulate. Sometimes that presents different sets of problems, bars to re-entry if you've been out of status for too long. So really take good care to watch your status carefully. One thing I want to note before I move away from this page, because it's a question that I get sometimes and it causes a little bit of confusion for some folks. Immigration goes by something that they call the last action. And as you can see, the document that you get through the airport is through CBP, or Customs and Border Protection. That is a separate agency under Department of Homeland Security than USCIS, which is Citizenship and Immigration Service. They're all under Homeland Security, but they don't necessarily follow each other or track very well. So what happens is that if you come into the United States and you're in F1 status and you enter through an airport, you're going to get a document from the online system that shows that you're in F1 status. If you then turn around and change your status to H1B, you'll get this new notice over here. But if you go and look on the system on the airport, that system is still going to show that you're in F1 status, because that shows your most recent entry through that system. So what you're going to want to take care to make note of is what was the most recent action that somebody in immigration took. So even if your airport document shows that you're in F1 status, if you have a more recently dated change of status that shows that you're in H1B, that's the status that controls. Now, it is, as I've alluded to, it is possible to change your status, and you can change from one form of non-immigrant status like F1 to another. However, you do have to be in status to change status. So if you go to school for a while, you graduate, and then you either don't do OPT or you let your OPT lapse and you just stay here and you're out of status all of a sudden, you're not going to be able to change over to H1B without departing and coming back in. So you do have to make sure that you have maintained that status. One thing that is always important to note, and a question I regularly get from students, is that you can only hold one status at a time. People will come to me and say, hey, I found I know I can't work as a student, but I found a great employer that's ready to hire me to work on the weekends. They'll sponsor an H1B for me. Can I do that? Well, theoretically, the answer is yes, you can do that. But from a practical standpoint, the only way to make that happen is that you would either need to depart the US on Friday night after you're done with school, re-enter an H1B status, work for the weekend, then leave again, and re-enter an F1 status before classes start on Monday morning. That doesn't sound very practical. You can try to make filings to change your status here without leaving, but it takes them months to make these decisions. So from a practical standpoint, it really doesn't work to hold multiple types of status in very short periods of time. And again, USCIS will issue you that approval notice with that new I-94 card. And you don't need to go get a new visa stamped into your passport unless you're leaving the United States. The visa is only important if you plan to travel internationally. I usually give an example of this. I had a client in years past who entered as a visitor, moved into an H3 training visa, then moved over to a J1 visa, then was able to change his status to an E2 visa. And so when he showed up in my office and showed me his passport, all he had was that visitor visa and that stamp, and his airport system just showed an entry in visitor status. but he had several subsequent changes of status, and he had been maintaining his immigration status the whole time. He had never left the United States, so he never needed to go to a consulate in order to get a new visa. So I know a lot of times people who are in student status will ask me, great, I've changed to H-1B. Do I need to leave now and go visit the consulate? And the answer is no. You don't have to do that. But if you're going to travel internationally, maybe to go home and visit family, friends, take a beach vacation to Mexico, you are going to have to get some sort of visa stamp placed in your passport in order to come back. So oftentimes people will ask me about what do I do after graduation? And as I mentioned, there are certain visa classes that allow for employment. Not all of them do. And so what we're going to talk about here today are visa classes that are specifically for employment. And so I listed these up here. This is not a full list of all of the visa classes, but this is something that a pretty broad list that covers most of the folks who are leaving. As Nathaniel mentioned, I know you guys have information about OPT and things like that, and I'm not going to cover too much of that here, except to say that most of you who are finishing a degree program should have a year of it. And if you have a STEM degree and you're working for a certain type of employer, you might give it up to 3 years of it. But really what we'll talk mostly about is what happens when I'm either done with OPT or I don't have OPT available and I'm done with that time as an F1 student. So by far the most common visa that people will use is something that is called an H-1B. And an H-1B is a visa for professionals that are working in a specialty occupation. A professional is generally defined as somebody who's got at least a 4-year bachelor's degree. And a specialty occupation is an occupation where you actually use the training and experience that you gained during your bachelor's level studies or during your most recent studies to perform the duties of the job. So I always use myself as an example when I'm explaining this. So I went to undergraduate school where I double majored. My double major was political science and sociology. And as soon as I was done, I decided not to go right to grad school. And I got a job with a clothing retail and import company. That would have been a terrible H-1B because the things I was doing in that job had nothing to do with political science and they had nothing to do with sociology. So I'd have been a terrible fit for something. Fast forward a few years, I go to law school, I get a law degree, and then I start working as a lawyer. That's a very good H-1B because at that point, I have an education that, in theory at least, prepares me for the job that I'm going to be performing when I get out working as a lawyer. So that they do need to match up. And so for some of you, I know that many of you are on the medical campus and you're probably thinking, yeah, I'm in dental school, I'm going to go work as a dentist. That makes sense. But if you are working, you do want to, when you're looking for a job and thinking about what your career is going to be, to qualify for an H-1B, you do want to make sure that job at least is tangentially related to what you've been studying. I will also mention to some of you as well, I've seen clients that may have an engineering degree undergrad. They go back and get like an MBA or some sort of a master's in a business related field, and then they go back to working as an engineer. It doesn't have to be necessarily for your most recent degree. You just do have to show at least a bachelor's degree in the field that you want to be working in. H-1B visas do require that the employer pay you at least the prevailing wage. And this is a Department of Labor requirement. The Department of Labor lists wage surveys, and that prevailing wage depends largely on the job that you're doing and the location where you're actually performing the job. Because obviously, if you were going to be working in a very small rural area in Wyoming, your wages as a software developer would probably be lower there than they would be in Seattle, Washington, and New York City. So it depends. I will mention that you do not necessarily have to be working full-time in order to obtain an H-1B visa. It is possible to do H-1Bs on a part-time basis. Typically with an H-1B visa, your initial H-1B is good for 3 years. You can get an additional 3-year extension of that for a total of 6 years. After 6 years, what is supposed to happen is that you're supposed to actually physically leave the United States for a year, and then you can reset that clock and then do another 6 years. But there are exceptions, and the big one is for people who are actually trying to pursue permanent residence and have gotten to certain milestones within that permanent residence process and either can't go any further or they're waiting for the government to process something. And in those cases, people can typically extend H-1B beyond the 6-year period of time. One of the best features about the H-1B is that it is a dual intent. And what that means, I know traveling when you're on an F1 or a J1 can cause quite a bit of anxiety for a lot of folks because the burden is on you to prove that you are going to depart the United States when you're done with your course of study or whatever training you're doing here. And that creates some limits in terms of what your intent can be, whether you're trying to pursue permanent residence, things like that. However, with the H-1B, that is a dual intent visa, which means you are welcome to go right ahead and pursue permanent residence. And the consular officers are not going to turn you around or refuse to issue the visa for that. And that's one of the big reasons why people like to get into H-1B. I think I hear from a lot of people who say, oh, I'm typically I have to go F1, H-1B, and then permanent residence. And I think a lot of people think that because of that dual intent feature. Now, with the H-1B visa, this is the part where it can get a little bit tricky. There are not an unlimited number of H-1B visas available each year. The number is the government and the government's fiscal year will issue 85,000 H-1B visas. Of those 85,000, 20,000 are reserved for people who have an advanced degree, meaning master's or higher, from a U.S. college or university. There is typically much greater demand for H-1B visas than there is supply of H-1B visas. So what happens is there is actually a lottery. And the system for performing the lottery is relatively new. It actually first came online in 2020. And with this, what happens is that your employer actually applies on your behalf and puts your name into the lottery. That lottery is open it'll open next week from March 1st to March 17th. And if you're selected, then your employer will be notified and you will be given a 90-day window when you can actually file the application itself. Once you file that application, even if no matter when it's approved, even if it's approved in June, July, August, the earliest you can start working in H-1B status is October 1st, which is when the government's fiscal year starts. Now, again, you guys as individuals cannot apply for even though the visa is in your name, it is an employer that must apply for you, and it is employer specific. People often say, can I do self-employment with that? Or, entrepreneurs oftentimes are curious about using H-1B. And I will tell you without getting into too many details that it is possible to do that. But one of the things that is required is that there has to be an employer-employee relationship. So some kind of business, a separate entity does need to be formed. And essentially that entity is what has to control the employer's work. What I oftentimes tell people is essentially you've got to set up your own business in such a way that your own business can fire you. Is a good way to think about that. So if there are people out there who are thinking, I want to do this through my own company or through a company I've formed with some partners, that's a good conversation to have so that we can figure out not only to try to do a lottery entry, but also is your company set up in such a way that even if you're selected, you're not going to run into problems down the road. So, now I will mention that there are certain employers that are exempt from the H-1B cap. And those are great if you can find one. Those employers are colleges and universities, certain governmental research institutions, and certain nonprofits that are affiliated with the college or university. And I always want to hit this point hard because a lot of people hear this and they think that any nonprofit is exempt from the cap, and that is not true. that nonprofit does have to have some pretty specific affiliation with a college or university in order to be exempt from that cap. Um, One thing that people always ask me or think that they might want to do is they say, hey, great, maybe I can just, get a job at the university for 6 months and then transfer over to that employer that is subject to the cap that I really want to work for. And unfortunately, you cannot do that. If you are working for a cap exempt organization, you cannot then transfer to a cap subject organization. You can work for both the cap exempt entity and the cap subject entity at the same time. They will allow concurrent employment, but you have to keep both jobs in order to make them work. A couple of timing considerations that I always want to mention with the H-1B. I mentioned before that you can start your H-1B employment on October 1st. And if some of you are looking at this and thinking, I graduated in May, my OPT is going to run out on May 30th, what do I do? Well, if you have been selected for the lottery and you filed that H-1B petition, whether it's approved or just pending, they will give you something that's called cap gap. It really bridges the time between that when your OPT is supposed to end all the way up to October 1st. So you are not necessarily going to be out of luck. And they will extend you through September 30th. So you fall asleep on the evening of September 30th in F1 status, and then you would automatically wake up the next day in H-1B. So people often ask me too, should I enter the lottery now? Because, you just said before, the H-1B is only good for 6 years, and I've got a bunch of years of OPT ahead of me. My advice generally is that you should enter the lottery as early as possible. What we've seen in the old days, what would happen is before all this lottery came online is that employers had to prepare the whole application and send it in, and you would either get a notice that you were accepted and for processing, or they'd send the whole thing back. And that was expensive for employers, but it did keep demand relatively low. People generally had a reasonable chance to be selected, 40 to 50% chance. What we've seen with the H-1B lottery, even COVID notwithstanding, is last year the odds of being selected in the lottery were between 25 and 30% because the barrier to entry is much lower. I tell people, as a taxpayer, it's a much more efficient system. There's a lower barrier to entry and everything, so I do appreciate that. As an immigration lawyer, I don't collect any of those fees, of course, so that's not my favorite part. But at the same time, it's a much better system. It does provide more access for everybody to jump into something like that. So I say enter the lottery as early as you can, so that you give yourself as many chances to be selected. There are ways, even if you are selected early in your OPT, to continue to use your OPT and potentially put off moving yourself to H-1B status, so you can explore those options. But I do generally advise people that's something that they're not allowed to look for. So those are the details on the H-1B process. Now, generally, if you're not selected in the H-1B process, I tell people you're going to have to tend to look either up or down in terms of what to do. And one way to look up is to see if you might qualify for an O1 visa as an individual of extraordinary ability. These are probably going to be, not officially, but generally, I would only consider something like this if you have a master's degree or above. If you have an undergraduate degree, but you have won some incredible prize, that might be an option there. But generally, it's going to be a challenge, because a lot of the criteria are really geared toward people who have things like scientific publications, people who have reviewed the work of others, people who have had their work featured in media, things like that. So what happens is that they want to see that you have had some sustained level of national or international acclaim, which may sound intimidating, but in my opinion and in my experience, that's not quite that high for O1 visas. There's a lot of ways to show that. They want to see that they give a list of 8 or 9 criteria that you can look at, and you can submit and say, I've got at least 3 of them. And generally, if you can show that these tend to show that you've gotten some acclaim or you've been recognized for your work, you can qualify for an O1 visa. O1 it's a really nice visa. It is good for typically 3 years on your initial visa, and then you do have to extend it 1 year at a time. So that can be a challenge. It also carries some dual intent, but it has what's called a modified dual intent. And part of what that means is that it's probably going to be a period of time where if you're pursuing permanent residence while you're on an O1 visa, you may be stuck in the United States. There are no caps to O1 visas. There's no restriction on start dates. There's no certain type of employer that can file one. They just want to see that you're going to work in your field. And as you can see, I've listed the fields there. I won't read them off to you, but I will say that the interpretation of those is very broad, such that it really covers just about any type of endeavor you want to get yourself into. So I can tell you in almost 20 years, I've never turned somebody away from an O1 because I didn't think they had the right category, and I've never had the government find that they didn't have the right category of science, arts, business, education. They're really broad. So another area where you may have the opportunity to go up or down is something called a J1 visa. Some of you may be on this right now. The J1 visa is unique because while it is a broad category, just like the F1 that issues you an I-20 form, the J1 issues you a DS 2019 form. And there are several categories that fall under the J1. Everything from college students coming to work for a summer or people coming to provide childcare, all the way up to people who are specialists, research scholars, professors. So it's a really wide range. And if you are the type of person who is graduating with potentially an advanced degree and you think you're going to move into a research scholar role, a J1 is a really nice option for that. There are some others for people who might be coming out of an undergraduate role, or for people who, even if they're not, might be looking at needing a little bit more training for what they do. And they do have categories under the J1 for both interns and for trainees. You can see the intern requirement here with the trainee. You can see this. The downside, there are a couple of real downsides to the J1s for interns and trainees. And they are, number one, that they're typically limited duration. In most cases, 18 months is the most you're going to be able to get as an intern or trainee. Sometimes it's less than that. It can be a challenge to change your status out of a J1. It can also, many J1s also carry a 2-year home residence requirement. And what that means is that they expect that you're going to go back to your home country for at least 2 years before you move over to an H-1B or pursue permanent residence or anything like that. So I've known J1s in the past. I knew one before I was practicing in this area who she was married to a U.S. citizen. She got she was working as a doctor, but she still had to do a couple of years back in her home country before she was able to come back. So they're not necessarily very forgiving. You do have to do a lot of advanced planning for some 2-year home residence requirements. To be clear, not everybody has. The other thing is that the J1 carries non-immigrant intent. So pursuing permanent residence while you're on a J1 can be a real challenge. Again, not impossible, but there are several timing considerations that you're going to want to factor in. And I'll mention something generally about intent here because it gets a little tricky. The government is interested in understanding what your intent was at the time you entered the U.S. They do recognize that intentions can change, but they will look at a lot of factors for something like that. So if you get a J1 and then a month later you're trying to get a green card, that could be a potential problem. If you got a J1 and entered 4 years ago and your life circumstances have changed, you may have a different conversation. It's very fact specific and it's very person to person, case by case. You do have to be conscious of that. So I'll mention a couple of other ones. They are not terribly common, but they can be used in some cases. The E1 and the E2 visas, the E1 is a treaty trader, E2 is a treaty investor. I've seen people who have been treaty investors where they invest money into a dental practice, for example, going to do this, or a medical practice. Um, that you probably have heard of these visa options where you have to invest $1 million. That is not what this is. Typically, you do need to make a substantial investment, but in many cases, that's more like $75,000 to $100,000. So the thresholds are not quite as high. They do typically want to see that this is going to grow into a business that does more than really provide you with a livelihood. So they do want to see that you're going to hire U.S. workers. Not every country has a treaty. There does need to be some sort of a treaty of commerce, or a treaty of navigation. So in order to do this, I will tell you that India, China, Russia, South Africa, those are the most common places where I see people who say, I want to do this, I want to do an E2, and unfortunately, there's no treaty. But these visas are nice because they do allow you to be your own boss if that's something that interests you. And they can be extended for really as long as you are owning, developing, and directing the business, which is great. L1 visas are intra-company transfers. These aren't very common again, but what they are is this is where we most commonly use people who are specialists or executives, managers who are transferring among large multinational companies. But if you worked abroad for, say, Microsoft, and then you came in and you got a degree, and now you'd like to go back to work for Microsoft again in the United States, this is something that might work for you. Also, there are some country-specific options. The TN for Canadian and Mexican professionals, the E3, which is a lot like an H-1B, but is open to Australians. And then there are also, if any of you happen to be citizens of Chile or Singapore, you guys get a special carve-out of the H-1B visa cap called an H-1B1. And so you don't typically have to deal with that whole H-1B cap, which is nice. Something to reassure everybody, spouses and children do get visas. Those are children under age of 21. Some spouses can work, some cannot. So you're just going to want to make sure you understand what your options are. For a lot of you who might be here on a J1 and you want to move to H1B, that may be great for you. Your J2 spouse who could be working right now and then maybe can't work when you move to H4, which is the spouse of an H1B, that can create some issues. So again, advanced planning. So I'll mention a couple of immigrant visa options, only to say that they are sometimes available in limited circumstances. I want to make sure I leave everybody plenty of time to ask questions, but typically with an immigrant visa, this is a lawful permanent resident green card. You don't have to, this is for life. You can work and travel without a visa. You can typically work for any employer. They are most often gained through either a close family relationship or through employment. And they can take several years. The employment side, well, before I get into that, I'll say there's always 2 or 3 steps that you have to do. The first steps are going to be qualifying steps that typically require either an employer, in most cases, an employer to sponsor you through either a perm labor certification, which is showing that there's not a qualified willing U.S. worker to take the job. Some people can skip that perm process with what we call a preference petition. Maybe certain outstanding professors and researchers, individuals of extraordinary ability, national interest waiver, and I'll talk about those in a minute. They can skip that perm labor certification. If you're going through a family process, you have to go through a relative petition. These are all filed by somebody else on your behalf. But once you get to that final step, that's when they would look at you and say, hey, are you otherwise eligible? That's done in your name as opposed to the national. They say, do you have any significant negative criminal history, negative immigration history? They make you go through a medical exam and background checks and all that stuff. So there's not as much of a focus on you until the end, at least on immigration side. But these are questions that anybody will ask and that you'll want to consider as you go forward, because they will let you get through the first couple of qualifying steps. Even if you have a serious criminal conviction, it will only get you at the end. So you would hate to, you want to make sure you're evaluating all of this. I always include this for my engineers in the crowd, the little flow chart about how the immigration system works. So you can keep that up there. And I have no problem releasing these to everybody. So, but generally, if you're going through an employment-based process, there are five employment-based categories of employment-based 1 through employment-based 5. They almost all require an employer to sponsor you, but there are a couple that are self-sponsorships, and I'll talk about those because those are the ones that I get most commonly asked about. One is the individual of extraordinary ability. You're thinking this sounds an awful lot like an O1 visa, and you're right. The standards on paper look very similar to an O1 visa. But in practice, it is a very high standard and it is generally very difficult to do in EB1 extraordinary ability. In fact, I've had several people who have been admitted on O1s and had them renewed, and they go to try to do an EB1 and they're turned down for not being extraordinary enough. And the courts have upheld that say you can do this. I put that note on the bottom about a Kazarian analysis. So what they say is it's similar to the O1. You have to show a certain number of accomplishments. Do I have publications? Has my work been cited? Have I judged the work of others? But then once you're finished with that, the government is going to take a step back and say, on the whole, does everything we're seeing about you tend to indicate that you're extraordinary? So it can be frustrating for people who say, yeah, I see that you've met these 3 standards, but you're just not quite good enough in our estimation, in our opinion. And that's a really hard, you can't appeal, it's hard to appeal something like that. It becomes really, what's more common is that people will use the national interest waiver, which can be employer sponsored as well, but it can also be self-sponsored. And what you're asking them to waive is actually that job offer, that minimum, that labor certification. You're saying, hey, my work is of substantial merit and national importance. I am well positioned to advance that, and they're usually looking at what kind of background you can advance it because you've been recognized by others as having some expertise in the field, and you've got grant money, things like that. And then the last standard is that on the whole, they say it would need to be beneficial to the U.S. to waive the job offer. And they think that that there's some inherent damage to the U.S. labor market, even though our unemployment is really low, that there's some inherent damage to the labor market for you to be able to just come in without some sort of a job offer. And you need to outweigh that by showing all of the benefits. So the national interest waiver is nice, and it is a lower standard. So for those of you who might be right out of school, or even if you're a postdoc who's in a job that isn't a permanent job, you don't have a job that can sponsor you necessarily, this can be a nice option. But for everybody else, you got to go through that perm labor certification or something like that. There are some outstanding researcher or professor options for people, but most people end up going through this perm labor certification process where you demonstrate there's not a qualified, willing U.S. worker. To get into some timing issues around this is step 1. This perm right now, they're taking like 15 to 18 months to get through. So it can be really frustrating because of some of the backlogs, and, COVID is part of it, but also just, more demand and gutting the agencies are not helping. Once you get through that perm, then you need to go to step 2, which is an I-140 immigrant petition, also filed by your employer. And then step 3 is the one where you go and file that in your company. Now, this is a part that's important, and this is a part where usually my folks in the audience who were born in China or India start to roll their eyes and get despondent. So don't lose faith, but there are only a limited number of permanent resident or immigrant visas issued each year through employment, and that number is 140,000. It is split among these 5 preference categories of employment-based 1 down through employment-based 5. Layered on top of that is another rule that says that no more than 7% of worldwide immigration can come from any single country, and they go by your country of birth. And what they say is that you cannot file that 3rd and final step unless there is a visa available. Now, over the years, there's no per country limits on H-1Bs or other visas. And what we've seen is that particularly for India, there are a larger number of people who hold the larger percentage of H-1B visa holders were born in India. And that has created a huge backlog. And so what the government says is, since you can't move on to that third and final step of this process until there's a green card or an immigrant visa available for you, what happens if you're from India is you either file your national interest waiver or file one of your perm and your I-140, your qualifying steps. And then you have to wait years before you can file that third and final step. So what they say, and here's the chart for this month, which is not great. And I'll show you. If you are in the EB2 category and you were born in India, you would have had to have filed your national interest waiver on or prior to October 8th, 2011, in order for you to be eligible to file that final step of the process. So what has happened for a lot of folks is that they have filed that. They may have completed a labor certification or a national interest waiver 10 years ago, and they're still not at a point where they can file and move on to that third and final step of the process. And as you can see, we talked about the H-1Bs only being good for 6 years. This is that backlog scenario. So if you were born in India, the chances of you being able to move straight from like a student or a J1 status into a green card are probably low. If you have to have been born in all other countries, you can see a C over here, and that means that there are visas that are currently available. With that, you don't have nearly as much of a wait. In fact, that means there is no wait at all. Even if you're in the EB2 category and you see November 1st of 2022, that's a 4-month wait. So that's much more of a viable option. I always tell people this is it's not a fair system, and it has gotten worse and worse over the years. I had a pair of clients at one point who were they had the same degree, same job, same company, same, they're basically, two very similar people, but one of them was born in Brazil and one of them was born in India. And I always remember this because the way it's set up, their perm labor certifications were filed on the day that one of my kids was born. And my kid was born in the afternoon. I wasn't working. I always just wanted to be, but so we had filed those in the morning. And then my client from Brazil got his green card when my son was about a year and a half old. My client from India got his green card while my son was in kindergarten. And so it's gotten worse since then. So it's really frustrating. People ask about family-based processes as well. And you do a similar thing where you have to verify relationships. In the family-based process, you can see there are long waits there as well. So if your brother or sister was born here and they want to sponsor you, they would have had to have sponsored you no matter what country you're from, sometime between, if you're from any country, let's say Canada, they would have had to sponsor you before March 22nd of 2007 in order for you to be able to move on. And just starting these green card processes does not give you the right to be here, does not give you the right to work. So you are going to have to maintain some sort of a non-immigrant visa the whole time that you're here. You can't just rely on starting a permanent residence. So that's part of why it becomes a real challenge for people to deal with this. And then all of a sudden, I've started declaring my intention to become a permanent resident. Maybe that limits my ability to travel on a J1 visa going forward. So maybe that isn't an option for me anymore. So there's a lot of factors that you're going to want to do. So a couple of things I always want to mention to people, and I've alluded to it before. Plan in advance. The fact that you're here right now is a good sign that you're thinking about these things. So always plan out in advance. When you're getting your OPT, plan in advance. Don't wait for yourself. Don't wait to graduate and then mosey into the international students office wondering about OPT. Think about it in advance. When you're talking to employers, I always want to emphasize that employers aren't obligated to sponsor you. And you may see job ads out there that say no H-1Bs. Particularly, we see that in tough economies, which we aren't in right now, thankfully, with jobs. But but they are not obligated to hire you. And if you're going through a process where, what they can ask you is, are you available and can you show the authorization to work in the United States? And you can probably say yes if you've got OPT. But I always think it's a good idea to bring it up on the front end. And I think so for two reasons. The main one is that if your employer is not interested, and absolutely not going to sponsor you, it's good to know that on the front end rather than wasting 4 to 6 months with an employer and then thinking, I'll just make myself so invaluable that they'll sponsor me. Because if they don't, then you're 4 to 6 months behind and you've got to go find out. So that's really the big reason. And it's also just, I think, good business from that standpoint of making sure that they know you're the kind of person that's going to be upfront with them. So as far as rumors and trends, I think the biggest recent development is the potential that H-1B and L-1 visa holders will be able to renew their visas in the US, which is awesome. As far as legislation is concerned, I would not bank with a mixed Congress of one side being Democrat, one side being Republican, and going into a presidential election. I would be shocked if we get any kind of meaningful immigration legislation passed, but you never know. I've been surprised before. So that's basically it. And I know I didn't leave a ton of time. I can stick around for as long as you guys need to. But if there are any questions, I'll open it up for you.
And if someone has a question, they can just come off mute real quickly, or they can drop here in the chat, and I can read it out loud. So feel free.
Or even if there's anything I covered that you want me to cover again, I'll certainly open it up.
So our question in the chat here is, how early do employers have to apply for the H-1B visa?
Good question. Employers generally, as I mentioned, that window is open between March 1st and March 17th this year. So they have to enter, and it's really only open once a year. In terms of what employers need to do, filing the lottery entry is not that hard. In fact, employers, I would say if employers can secure, some help with that, if they need help, we can typically do it with a couple of days of notice or a week of notice in a pinch. So it's not the kind of thing that they have to plan months in advance for. The questions they ask in the lottery entry are really basic. So it's generally not too challenging to get that done. One thing I should mention about the lottery entry as well is that you can only have a single entry with a single employer. So if your employer wants to get in there and thinks, I'll just enter, Bobby here 5 or 6 times and we'll increase our odds. If they discover that, they will invalidate all of your entries. So you can't enter more than once with the same employer. However, if you have multiple employers that are all willing to enter you into the lottery and they are distinct separate businesses, it is certainly possible for 3 or 4 different potential employers to enter you into the lottery. I see a second one. It says, would a PhD student be qualified to apply for EB1 or EB2? Potentially both. With that EB1, it's an individual of extraordinary ability. So that is a challenging standard for if you're going to try to file in that category. I generally tell people if you are an early career person, that's probably not an ideal fit for you. If you have an employer that's ready to sponsor you for the outstanding professor or researcher, which is another EB1 category, a PhD student, that would probably work if you are working for a specific employer. If you are working, if you're not working for an employer and you're just a student right now without job support, then you would probably be looking at that EB2 would probably be the best bet. But again, it's very specific. So I'm glancing at my other screen.
Yeah, very, very long one just now dropped in there if you want to see that one.
Yeah, I see somebody ask, what do I mean distinct businesses? What happens if several organizations but they're all within the same industry. Distinct businesses means an individual business unit. Whenever, and just for some background, when a business forms in the US and they want to put people on payroll, typically what they have to do is apply for something called a Federal Employer Identification Number, or FEIN, and that is what makes your business unique. So if you are thinking, well, Microsoft wants me to work on their chatbot and Google wants me to work on their chatbot, those are two separate companies that can do that. It's not really the industry necessarily. Yeah, it's separate companies. Somebody asked about multinational work. The L1 multinational. Something to be clear about with the L1, one of the things that they want to see is that you have worked for one of the previous 3 years in either a managerial, executive, or specialized knowledge capacity. But what they are looking back at as the 3 years prior to your entry into the United States. So if you worked as a manager for a company abroad for at least, for 3 years, and then you came here and you've been in school for 4 years, and now you'd like to go work for a related company, you can typically do that. Now, to be clear, when I say a related company, what that means is that they have to have a relationship with the company you worked outside of the US. Either one of them owns the other, or they both have a common owner. So that's what works. But the fact that it's been maybe more than 3 years since you entered the United States as a student is still okay. So for this particular question, the person mentioned stopping working with them in January of 2022. If you entered the US in January 2022 in F1 or J1 and started working, and then you want to go work for their US sister company now, you could certainly do so. If I'm eligible for a STEM OPT extension, should I still ask my employer to file an H-1B? Michelle, tell me that you're still eligible for it.
Right? And in no way, shape, or form am I eligible for a STEM LPT extension.
No, thank you. It's a good point. But I think even if you're eligible, my opinion is that you should go ahead and try to enter that lottery. You can do that early. And as I mentioned, you can still use your STEM OPT, and you can set your H-1B up in a way that the only way for you to activate it is to leave and come back in. So in theory, you could even finish your STEM OPT and then go back and get your H-1B after that. So you have time for that.
And I'll respond to the next one there from Keshav. Keshav, as previously mentioned, OPT is not handled through an attorney. Typically, it is handled through our office. And that information that you asked is all in our OPT course that we have. If you haven't taken that, I'm about to drop the link here into the chat. But that is where you can learn all that. That is required as well for you to apply for OPT with our office. But you can find all that information on the course as well as information in our chat. We're not going to talk about your specific case in regards to OPT today.
And what I'll say to you, what I will say about OPT is don't put off reading that link or looking through that course until you're done with finals. Do it sooner rather than later so that you can give Michelle and Nathaniel all the time they need to do what they need to do and put you in the best position. What if I would like to pursue a master's degree while on a work visa? Do I return to F1 visa and will that invalidate my H-1B? Great question. The good news is that what they're trying to work, or what they try to make a judgment on, is what is your primary purpose for being here? And so if you are on H-1B and working full time and you do night classes, do like an executive MBA or a part-time degree, that is absolutely something that you can do. They will allow you to pursue a course of study while you're on H-1B. So it's something to make note of. You can do that, sure. See our time. Oh, there we go. Does an employee under OPT have the same rights and benefits as a regular employee? What are our tax requirements? I'm not sure I can speak super knowledgeably, except to say that there is certain when you get, for those of you who have not received a paycheck in the United States yet, It can often be a mildly demoralizing process. And I say this as the father of a couple of teenagers who've got their first jobs recently, because they think they're getting paid a certain amount. And they look at all the money that gets withheld out of it for things like income tax and things like that. There are certain types of taxes and withholding that are not supposed to be withheld for F1 students. And I believe that they are the FICA tax, and I think the Social Security, but I could have that wrong. What I would strongly suggest is that when you get a job, you talk to your payroll department and say, hey, I understand that F1 people are treated a little bit differently. They will go through their payroll provider and they'll make sure that that happens. The one thing you want to be careful about is as soon as you move from F1 to H1B, then you get then they're going to take all that stuff again. So you just want to make sure that that you keep everybody in the loop about your status.
And in general, in the US though, Brad, you would say that a foreign employee has the same rights as a US employer. However, something that I would say is also true, and this is something that is kind of interesting, and we run into this periodically, is that a employer can discriminate based on an immigration status, but they can't discriminate for hiring or other things based on your nationality or other things along those lines. And so you still retain all the same rights that a US employer would, except for that immigration status piece that is different because of that is a need for you to be able to work.
Yes, that's correct. And so they shouldn't be paying you less because you are not from the United States or because you've got OPT or something like that. You should be treated the same as all the other. So one thing I will mention though, from many people come from from countries where it's very common to have an employment contract. It is not common to have an employment contract in the United States outside of some very limited industries. Most of the time, what you are considered an at-will employee, which means that really they can terminate you for any time for any reason. They don't have to have cause, and that's not just you. That's just about everybody works under an at-will status. Okay, I see another.
I want to go back to Rama's question about the question about pursuing the master's degree while on a work visa. And I want to just make clear that the answer that Brad gave is absolutely correct. If that work visa is an L1 or an H1B or an O1, if it's OPT, it's not okay.
That is different. Yes, thank you for that clarification, Michelle. And Rama, what I will tell you here, since we're not going to discuss some OPT in depth here, if you have additional questions, both of those things that you've mentioned are true. Please set a time to meet with one of our specialists in a walk-in, or you can do an appointment if you have some additional questions regarding OPT and the application regarding that. Okay.
And something I'll encourage all of you guys who are dealing with student issues and things like this is it is always way better to ask permission than to beg forgiveness afterward. If you're not sure whether you can do something or not in your specific facts in your specific case, bring it to the office. Consult an attorney, consult somebody, because in many cases, once you've done something, it's the old saying of you can't put the toothpaste back into the tube. You can't unring the bell. So you're way better off to ask permission about what you can do before you make any actions that you can't do that. So.
As mentioned, we're not going to talk about OPT here, Rama. So regardless of the next question, I suggest you to set an appointment or come to one of our walk-ins to meet with one of our specialists. Thank you.
All right. Any other questions in that chat? Last call. Yes.
All right. Well, thank you all for attending. I thank Brad here. We had a lot of students that did sign up that didn't attend today, so we probably will be sending this out to our students anyways. But if you do have any additional questions, in general, in regards to your immigration status, always feel free to, like I said, send an appointment with one of our specialists, or you can always email ISSS or come to our walk-ins. And Brad's information is obviously here at the bottom if you have more questions that are kind of not related to anything that we would process, but are just sort of in those other realms, and he can walk you through what that might look like if you would like to work with him for any future services and something along those lines. Anything else here, Brad, before I end everything here?
No, thank you all for your time and your questions. I appreciate it.
Great, thank you.